All right, so chairing this panel is my wonderful colleague, Professor Raymond Koo, who is also the director of our Cyberspace Law and Policy Office, and he does really excellent work in this area, and there was nobody that I could think of that would be better to chair this panel. I turn it over to you, Ray.
Well, thank you, Michael. Thank you, Dean Scharf. Today we're here for a very timely and challenging topic, right? So we're talking about social media and its role in fostering atrocities, though we could probably include a lot broader topic and subject area for what social media can actually be fostering. And to my right, I'd like to introduce our panelists. First is attorney Jenny Domino. She is the Satter Human Rights Fellow at Harvard Law School. And then to her right is Professor Rebecca Hamilton at American University in Washington College of Law. And then Professor David Sloss from Santa Clara University School of Law. Now, the schedule had Professor Van Schenk from Stanford, but unfortunately she couldn't join us today. So the three panelists here have written some wonderful papers, and I highly recommend that you read them. Because of the issue of time, I'd like to just give them 5 minutes each to kind of briefly set the stage for the problem and kind of why we're here today talking about it in this particular conference. So, Jenny?
Thank you so much, and I'd like to thank Dean Michael Scharf for inviting me for this conference. I'm really excited to be here because I think this topic is very important for two reasons. And the first reason is that there's a lot of conversation going on about platform regulation, but I think not a lot of focus on how it affects the incitement landscape in the global south, specifically in mass atrocity settings. So just to provide some context, last year in September 2018, the UN fact-finding mission in Myanmar issued a report which recommended further investigation of potential international crimes occurring in Myanmar. But for purposes of my discussion today, I would like to focus on Facebook's role. So the FFM, the fact-finding mission in Myanmar, found that Facebook served as a useful instrument in the spread of hate speech of different leading figures in the country, religious figures, government officials, other influential figures. And it further found that in Myanmar, Facebook is considered the internet. And so my paper is going to focus on that. And I think what is not focused too much is that in a context like Myanmar, where a country is undergoing political transition, the effect of platforms like Facebook can be very potent. And so, and also that the public infrastructure in the country is weak. So I think that the Facebook issue in Myanmar is important for that reason, for that first reason. The second is the normative implications of that. I don't know if you're familiar, but soon after the FFM released its report, Facebook took down the official Facebook page of the commander-in-chief of the Myanmar military. And for me, that is remarkable because for the first time, you have a private, non-state entity taking down state speech. And so right now, there hasn't been a lot of focus on that and what implications are for international legal theory. And so I would like to focus on the normative for this panel discussion. And I would like to say that the Facebook issue in Myanmar exposes two things. First, it highlights a gap in legal responsibility for various actors in international law. So just to use the frame of the Genocide Convention, the Genocide Convention clearly provides responsibility for states, which is the duty to prevent and punish genocide, including the crime of incitement, direct and public incitement to commit genocide. And with respect to natural persons, the the genocide framework under the Genocide Convention and the Rome Statute, and also in incitement jurisprudence of ad hoc tribunals, clearly provides for prosecution for speakers and inciters. Now, the gap here applies to corporations, and a good example here is a platform like Facebook, where under international law, there's no clear legal responsibility for corporations. Now, here, the UN Guiding Principles on Business and Human Rights becomes relevant. It's a soft law framework that provides for the corporate responsibility to respect human rights. And when I say this, it simply means that corporations can use human rights as normative content in the way they do their business operations. But their failure to do that does not give rise to any legal responsibility, in contrast to states and natural persons under international law. So it highlights that gap. Now, current discourse on this, on corporate responsibility and corporate liability, is mainly framed through a criminal law lens. So one example of this is the move to amend the Rome Statute provision on personal jurisdiction to extend to prosecution of corporations. Another example of this is being talked about in the draft Business and Human Rights Treaty that provides for domestic prosecution of corporations through the state, through a national mechanism. And to be fair, the draft BHR Treaty, the Business and Human Rights Treaty, also provides for civil and administrative liabilities. But my focus is, my point here is the focus on crime as a dominant discourse to conceptualize harm of corporations. And my second important point here is that the Facebook issue in Myanmar exposes the conceptual limitations of framing harm through the discourse of crime. So, in a way, the Facebook issue unsettles current thinking on corporate liability, because here you have a third-party platform. So I guess here it would be helpful to talk a little bit about incitement, jurisprudence, and prosecution. So before, you have a publisher or a broadcaster speaking on traditional media like a newspaper or radio. And under international criminal law, those people were prosecuted for incitement. So we have Julius Streicher, and although he was prosecuted for crimes against humanity, there was no Genocide Convention yet at that time that prosecuted incitement. He was prosecuted for allowing the publication of articles in the newspaper. And then you have the jurisprudence of Rwanda, which provided for the prosecution of radio broadcasters. Now, the difference here is that in the Facebook issue in Myanmar, you have a speaker, you have an inciter posting on the platform. But the platform itself is not privy to the publication of that content. So what is its involvement? Descriptively, its involvement is that through their community standards, community guidelines, and their content moderation policy, and the way they enforce that through human reviewers and technology, they're involved because it allows for other people to organize their content for wide dissemination. But in contrast to the traditional editor or broadcaster or publisher, they do not exactly know. They're not privy to the actual content because they are distanced from the act, both physically and mentally. And so, if you think about it that way, the platform involvement in instances of speech crimes does not really fit the framework of criminal law, where, for example, in cases of complicity, you need knowledge, and arguably under the Rome Statute, you need purpose to facilitate the criminal design. Here in the Facebook issue, they're distanced from that, they operate outside of that cognitive frame. And so I'm about to end. I'm very conscious of the time. And so what is the point of all this? Why am I speaking about this? I'm speaking about this to say that the dominant discourse to frame harm under international law has been this turn to criminal law. And I'm not saying that we should subvert that and remove that. I think international criminal law is meant to properly try individuals, and I support that. But it also, this fixation on criminal law tends to overshadow other possible discourses of conceptualizing harm. And I think the Facebook issue in Myanmar highlights that. Yeah, I'll leave it at that.
All right, thank you for that excellent summary and introduction. Right, well, you'll find that the three panelists, actually there's a lot of consensus among them on this view, and I will have to be the gadfly in this particular right? So Rebecca.
Hi everyone, thank you again to Michael. This is just an amazing group of people to be talking about this, and I'm particularly glad that we've got a social media panel because so many of the atrocity prevention conversations I'm having these days have some kind of interaction with social media, whether it is on the side of social media as a platform for incitement or social media as a platform for being able to get the message out to the world about crimes that are happening. And so I don't want to lose that there are two sides to this conversation. My current writing is based on an immense frustration that right now we are having a regulatory conversation in the US on social media spurred by Russian election interference, Cambridge Analytica. Meanwhile, in the rest of the world, these things have been happening, harms fueled by social media that have been leaving communities absolutely devastated and destroyed. And the US conversation is coming very late to this reality, I think. But before circling back to that, I thought it could be useful, given probably the mix of social media expertise we have in the audience, to do a bit of a 101 on what does content moderation actually look like. Because we have, and Jen did a great explanation of how this is sort of a different medium that we haven't quite figured out how to fit into pre-existing legal categories. So humanity is now putting everything online, the good, the bad, and the very, very ugly. And the platforms themselves have no interest in the very, very ugly getting online. And so they have set up community standards, different kinds of rules that come out of the corporation itself to say what they do and do not want online. And then the question is, well, how do you enforce that? And there are basically three levels of enforcement. And the first one is algorithmic, and this comes out of the scale of content we're dealing with. So a couple of stats I think are useful to give you a flavor of this. 350 million Facebook photos uploaded each day, 400 hours of YouTube video each minute, 6,000 tweets per second. An absolutely overwhelming scale of content. And so you cannot leave this just to human moderation, which is why you have to build in algorithmic content moderation. The problem is algorithms are really bad at detecting hate speech. Hate speech is so contextually dependent that while we've had some success at certain types of content that we don't want online, child pornography, for example, we do a pretty effective job at algorithmic screening out. When it comes to hate, this is really not working very well. So the next layer is human moderation, and these are the paid content moderators that are working mostly in the global south under not, I think we can just say, awful working conditions on the whole, and are trying to follow a set of rules that are operationalized for when something comes across their screen. Does this fall inside or outside the category of what my platform allows? And then the backup to all of this is everyone here who is on social media. We are also content moderators. There will be a button somewhere on your screen that allows you to report content you find offensive. And that is a pretty decent backstop if you can assume a society where most people agree that content that we would say objectively is offensive is indeed offensive. It doesn't translate very well to a context like Myanmar, where you have had over generations now persecution against the Rohingya, such that that content can go online without anybody flagging it as offensive. It is seen as acceptable and normal. Now, of course, it's not true that not anybody flags it. There are incredibly dedicated civil society organizations that are doing that flagging, but we need to note that is them stepping into that role. People who are already working under incredible resource constraints and who are trying to get these platforms that are based in Silicon Valley to pay attention to the particular context that they're dealing with. So that I hope gives us a little bit of a common page for starting this conversation. If I had to summarize what I think is one of the core challenges right now, is that the major social media platforms are based in Silicon Valley, do not historically have a great track record of diversity in their staffing, and they have launched into markets that they basically lack the cultural competence to enter into. And so their model is designed around a liberal democracy. And then when you roll your product out into a market where they're coming out of decades of military rule in the context of Myanmar, coming out of a civil war, think of Sri Lanka, think of South Sudan, where the population does not have faith that there is rule of law that will be upheld, and where there is no independent media or very weak independent media as a check on false rumors flying. You know, this ethnic group that has historically attacked your community is about to attack your village now. You have no faith that there's any law enforcement mechanism that will step in, and so you respond by going on the defensive even though it was a false rumor. And so that is the crux of the problem that these companies are now scrambling to get on top of. It is because of the work of Global South civil society organizations, mainstream media, that we are, and the UN with the fact-finding mission, that we are now starting to see movement to catch up with these problems. Thanks.
Thank you.
Well, thanks to Michael and the conference organizers for including me in this. I'm very happy to be here. Does anyone have the slide that I was going to put up? There should be a slide popping up here. I don't know if not, we'll do without it, but there we go. So I'm going to be directing your attention to a very important federal statute, but which is now up on the board. That essentially what this statute does is it immunizes internet companies from liability, civil liability, for any content that is posted on their platform by somebody else. And let me go back to the example that Jenny was talking about from Myanmar. I mean, if this statute did not exist, you could very easily imagine a state tort law claim against Facebook for being negligent in allowing its platform to be used for basically inciting genocide in Myanmar. And that, at least on its face, looks like a pretty plausible state tort law claim against Facebook. But the claim becomes impossible under this statute because the statute effectively grants Facebook and other internet companies immunity from civil liability for any content posted on their platforms by somebody else. And so a lot of my work is focused on how do we sort of take international norms and implement them into domestic legal systems. And I want to suggest to you that if we take seriously our duty to prevent crimes against humanity, which Sean Murphy was talking about earlier, as well as the duty to prevent genocide, One useful mechanism for the U.S. for doing that would be to essentially write an exception into this statute that essentially says, look, if you allow your platform to be used to incite or induce these kinds of mass atrocity crimes, you, the company, can be held liable for this. This raises a whole host of questions and a whole host of potential objections, and I think we'll get into that in some of the discussion here, and I expect Ray may have a different view on this, so I'll let him raise the objections. Let me just say, and this really dovetails a lot with what Jenny was saying. If we focus specifically on the duty to prevent, and there's no question that as a matter of treaty law, we have a duty to prevent genocide, and I think there's a strong case that as a matter of customary international law, we have a duty to prevent crimes against humanity. And if Sean's project is successful, we may at some point down the road have a treaty-based duty to prevent crimes against humanity. If you think that social media companies are actually contributing in some way to the commission of these crimes, criminal law is just not a good tool to deal with that. You can't make a plausible argument that anybody in Facebook has the requisite mens rea for criminal liability for whatever they're doing to sort of contribute to the commission of these crimes. But you can make a plausible argument that they're being negligent in allowing their platforms to be used for this purpose, and that they certainly have a capacity to do something about that. Now, in fairness to the companies, they've started to do something about that, but in a very reactive mode, right? So before all of this came down in Myanmar, they had virtually nobody who was working for the company who actually spoke Burmese. So how do you do content moderation of Burmese content if you don't have somebody who actually can read and understand it, right? Now, they've hired more people to do that, but, have they done that in the dozens of countries around the world where there's a serious risk of this type of thing happening? I don't think so, from what I've been able to see. You guys may have some better numbers on that than I do, but it looks like they're sort of playing catch-up, right? So civil liability would actually give them a real incentive to make the investment in hiring people to do content moderation in the variety of countries around where, we can say with some level of confidence that there's a high risk that this kind of thing could happen at some point in the next few years. And rather than waiting until it does happen and then going and sort of hiring the content moderators to deal with it after the fact, if they know there's civil liability, it gives them a financial incentive to make that investment up front, and I think that would be a good thing. So I'll stop there, and we'll have a discussion.
Okay, thank you. So I will pose this to the panel, and it's not just being a gadfly. As David, you left off, civil liability could certainly create a set of incentives, right? And one of the reasons why Congress passed the Communications Decency Act and the 230 Safe Harbor in the first place was that it would have perverse incentives, right? That the chill of civil liability would essentially lead companies like Facebook or America Online or AT&T, for that matter, to start blocking content because in many ways it's not in their interest to necessarily have controversial content, right? So if they decided that, pretty videos of kittens is how they can make enough money, then we wouldn't be discussing politics at all. While there are different countries with different values, right? How should the U.S. respond to an American company when we still in this country maintain a very strong sense of free speech in the absence of incitement? Right? And of course, that's the problem that you all are raising. Facebook is not trying to incite anything, right? They're just distributing speech and communication.
Sure, I'll start. So I think that there are ways to do this that are fully consistent with free speech norms in this country. But there's no question that that if you impose civil liability on companies, it does give them a reason to restrict too much speech rather than too little speech, right? If there's going to be a gray area there, there's going to be some hard line drawing, and just a sort of that by itself does raise the risk of they limit too much speech, right? So one of the things that I include in my proposal is that the standard that would be imposed on them under what I'm suggesting is sort of make reasonable good faith efforts to prevent this stuff. You cannot impose a sort of an absolute liability regime where, if one message gets out on the platform, you're liable. I think that's too strict. It doesn't make sense. And I also think that this is an area where sort of public-private collaboration would make a lot of sense. So I suggest that you actually have a group that includes both industry and government sort of coming up with a set of best practices of here's, our collective wisdom of the best way to deal with this problem. And you would build into the statute a sort of a safe harbor for companies that basically conform with these best practices that are worked out jointly between industry and government. And I think that, in my view, provides sufficient protection for free speech while still giving them a real incentive to do a better job in limiting the really, dangerous, harmful material that is out there.
Right. So I think there needs to be a little pushback on this idea that just because these companies are based in the US and we're all grounded in First Amendment law, that First Amendment has to be the holy grail for how we think about the regulation of these companies, because they are operating on a global scale. And the First Amendment is exceptional when you look at it in global context. So I think an appreciation of that as a starting point is helpful. That said, the freedom of expression concerns are absolutely global and grounded in international law. And, one of my concerns, and you'll all get to read David's great proposal, which I think is a fantastic starting point for thinking through how to operationalize this. And I'm 100% on board with looking at this through a civil liability lens. But the idea that you're going to start imposing civil liability at the point, you lose your immunity for civil liability at the point where content has been on your platform for 24 hours, makes me nervous when we look at the lessons learned to date from what has happened when Germany has tried to impose a similar kind of law. And the EU has been moving this way as well on terrorist content. We do see over-removal, and that we can anticipate, right? If you're a company, it makes sense to over-remove in the face of a threat of liability or massive fines in the case of the law that the German government has passed. But it is not just that. It's not just that you get overbroad removal. You get overbroad removal in a way that systematically discriminates against the most vulnerable populations. So the rules around 24-hour takedown of terrorist content, what we are seeing, and it's hard to get good data, but what we are seeing is that it is picking up because the platforms are having to rely on this by algorithm, right? Because you can't deal at a 24-hour takedown with the kind of scale that they're dealing with without turning to algorithmic content moderation. The algorithms pull down 200,000 videos that Syrian activists were doing to document the war crimes that they were seeing happening around them. And the algorithm wasn't able to distinguish between that material and terrorist content. It wasn't making the same mistakes when it came to white nationalist content that you might otherwise consider as terrorist. So I think, the devil is in the detail of all of this. It is really tricky to operationalize, but that doesn't mean that we shouldn't be having exactly these conversations.
Actually, if I could jump right in on that one, and then I'll let Jen go. Actually, the algorithms do have, I agree that there's certainly a kind of a cultural bias and a historical bias in the way the social media platforms are kind of doing their screening. And to use the example of white nationalism, Twitter pointed out a couple of weeks ago that they do have algorithms that, like the algorithms for terrorism, would be able to capture white nationalist and white supremacist speech. They just refuse to implement them because they're concerned that it picks up too much speech from Republicans and conservative politicians and elected officials in the United States, right? So there's this kind of indifference to it if we're talking about individuals outside of the United States, especially those disadvantaged groups, but of course in the United States they have a slightly different valuation.
Cultural competence, again.
Exactly, right. Mm-hmm.
Yeah, actually, I want to go outside the US for a bit because this topic usually affects places not inside the US. But so I think that David's proposal is great, but ultimately, I think this is where I see international law can be very useful because I think there are two questions here. First is, how can international human rights law guide platforms like Facebook in content moderation? And second, how do we ensure, if the answer to the first question is yes, how do we ensure that normative alignment? Should that come from state regulation where platforms are domiciled? Should that come from an international community? And if it's the latter, what kind of mechanism do we envision for governing these platforms? And so I think that I agree with civil liability, but I also think that there should be an international approach to this question. But the problem is the international law is more focused on criminal law and in prosecuting speakers. And again, I support that move, but we should open up conceptual possibilities such as tort. And here I'm not saying that we should have an international version of an alien tort statute. I'm saying I'm limiting my response to the fact that we should start thinking about different formulations that crime has cognitively constrained us from thinking. Yeah.
Okay, so I'd like, go ahead, do you have a
Well,
comment?
I just wanted to connect up a thread. Layla's comment in the last panel about how we're at this moment in international law of the workaround, which really resonated. But I think in this space, there is a moment for really building from the ground up. And it is a moment to spend some time thinking about what would amazing look like here. We're not in the situation of having to just do workarounds. Can we build something from the ground up that really is what we want?
Can I just add?
Yeah.
So on the, because I wanted to respond to Rebecca on the sort of 24-hour takedown. So I did put something in my proposal about a 24-hour takedown requirement, which is modeled on, there's something like that now in German law and also in French law. The French have adopted this too. But I think it plays out really differently if you're focused on mass atrocity crimes versus hate speech, right? They're focused on hate speech, and hate speech is going on in, forms all the time, right? Mass atrocity crimes are not happening a whole lot. And so it's easier actually to sort of develop mechanisms for dealing with that stuff because what you're worried about is a risk of some remark, or some series of remarks sparking mass violence, right? That's very different than sort of day-to-day hate speech. And in fact, if you're Facebook, you can basically write off half of the world, as there are countries out there where just the risk that speech is going to spark mass violence is low enough that any speech that is happening in those places directed to those communities, right, is not in the ballpark of what we're worried about, right? So I do think that I recognize that what you're saying is absolutely right in terms of the way this is sort of played out in the hate speech context in Europe. But if we're thinking about the places in the world where there's a real risk of sort of mass atrocity and mass violence, and that's the focus rather than hate speech, I think that it's a more manageable problem to come up with a system that actually could work. And if you take something down in 24 hours and then you decide it was innocuous, you can put it back up, right? It can go back up. There's nothing that says that that initial decision can't be reversed and you can't sort of allow it to go forward. But it sort of errs on the side of caution up front, and then you can have more time for reflection. So.
Go.
Can I add on to something? So I'd just like to extend what David was saying. So I think that, in international criminal jurisprudence, hate speech has formed the basis of a prosecution and a conviction for persecution. But, so I think the question that we should ask is, what makes hate speech across jurisdictions different from one another? And I think this is what Rebecca was saying a while ago about incitement landscapes and how speech landscapes are very important not just in international criminal prosecutions, but also in content moderation policies and in crafting international law mechanisms that should govern content moderation. Because the reception, I think what makes it, there's no one answer to. So I guess what I'm trying to point out here is we cannot tell Facebook the sort of content that they should take down. We cannot give them a set of words that they can simply feed into the data and that they can implement. What makes it different is precisely the speech landscape. And that's why even in the ICCPR, Article 19 and 20, it leaves it to the states to legislate within their country on what kinds of speech they should deem criminal or should be prohibited. And that's why in the First Amendment is different from, let's say, Europe, in Germany. So I cannot highlight the importance of the speech landscape, especially, for example, in Myanmar, where imagine 5 decades of military rule, you still have a lot of self-censorship going on there. And how do words and statements impact a country in political transition? In a country where there's still a lot of state-owned media whose resources and reach still outweigh non-state-owned media. And how does the presence of Facebook affect the public discourse? So. Yeah.
Okay, so if I can follow up then, so there are 2 particular questions that seem to be coming out of this discussion, right? One is the possibility or even the desirability of recognizing one set of norms or set of values under these circumstances versus multiple norms and certainly contextual efforts to regulate content. And the other, this is where I'll put on Facebook and Mark Zuckerberg's hat, right? They've come out and said, please give us guidance, right? That because we are operating in all these jurisdictions around the world and we are not capable of determining with sensitivity what speech is particularly inflammatory in Myanmar, but not necessarily in Germany or in the United States. And so they've created a system, right? One that involves multiple layers. And I don't know if how many people know, Facebook just announced the other day that they're going to create essentially an independent oversight board that will, according to their proposal, act as the final arbiter in terms of content moderation. It would exist independently of the company. Zuckerberg would not have any ability to overrule their decisions, and it's supposed to follow a judicial model where the members of the board would write opinions that would be published to the public, and then they're supposed to apply kind of precedential effect to that. Right? So if you were to advise these companies, what else can they do? Right? Because it's not just Facebook, it's Twitter, it's Snapchat, it's essentially any ISP or any computer service that deals with issues and communicates data outside of the United States or beyond the United States. If you're in China and you're running a network there, what responsibilities would they have to set up both processes and deal with an infinite number of variables?
Right. Um, so I want to just sort of underscore, double highlight Jen's point about what is the local speech landscape. It is true that it is good that Facebook, and it's not just Facebook, we shouldn't just be having a Facebook conversation here, has recognized that they have been failing. And it is a classic move to say, okay, well, help us out, government. Move the spotlight off us from a little bit, and what are you doing? But really, this is going to come down, I truly believe at the end of the day, to them investing in the local knowledge that is there, that knows what the local speech landscape looks like. And right now that work is being done by poorly funded civil society organizations who are just trying to stop things burning down. So if you are an extraordinarily wealthy company, invest there. They already have the knowledge base, and that would be a great place to start. I think the Oversight Board is a really interesting and potentially positive development, but let's be clear, it is only going to get at the tiniest fraction of the content that we're dealing with.
Right, nor does it address the issue of cultural context, right? So
right.
40 people, depending on where they come from, may have a broad understanding or may not.
Right, and there's a fear that I don't think is unfounded at this point, that we all get really excited by the fact that, great, there's an oversight board now, but we haven't actually addressed the very real issues that are there on the ground, not just in Myanmar. I could give a long list, but it's a lot of people that are affected by this.
Yeah, so let me add a couple things here. One is, and I put something about this in my paper, I'll sort of give a shout out to the U.S. Holocaust Museum Early Warning Project. They do a really good job of ranking countries in the world by sort of the risk, where is the highest risk of mass atrocity, basically. So that's a great place for these companies to start in terms of thinking about, okay, we can't invest everywhere all at once. Where are the places that we should invest? Because I agree totally with my co-panelists. You need some cultural sensitivity here. It's going to be different in different places. They can't just go out there and say, okay, suddenly we're going to put 100 people on the ground in like every country in the world. I mean, they could, but that's probably not likely going to happen. But, you know, this tool is actually a great tool for saying, where are the places where the risk is greatest? Let's start there and sort of get resources on the ground there, right? Now, the other thing, my good friend Beth Van Skok, who couldn't be with us today, but who was supposed to be on this panel, she and I, a little while ago, started an initiative. We were trying to push for the idea that Facebook, Google, and Twitter could get together to actually fund positions with these human rights organizations in some key countries, where these people would be sort of dual-hatted. And you'd have people on the ground there who have one hat they're working for Human Rights Watch, and the other hat they're working for this sort of consortium of, you know, Google, Facebook, and Twitter or something like that. And I think that kind of collaboration could be hugely helpful, right? Because I mean, I don't know that by you know, the companies just putting people on the ground in country, they're actually going to sort of pick up the cultural sensitivity that they need to pick up. But you do have civil society organizations on the ground there, and getting some collaboration between them, you know, where the companies can fund it, and you know, one of the things that you know, that could be particularly helpful here, and this is something I learned from reviewing a paper of Becca's a while ago for a different conference, was, you know, I don't know if you talked about this in your paper, Jenny, but, you know, in the sort of, in a couple of different cases, you've had people on the ground basically screaming out to headquarters back in Mountain View or whatever, saying, hey, there's this terrible stuff going on, do something about it, and it's just ignored, right? So if you have people who are actually dual-hatted and they've got, you know, they're wearing a sort of a Google hat at the same time they're wearing a sort of an NGO hat, then they've got a channel to communicate to the right people in Google and say, hey, you got to deal with this right now. This is a problem, right? So I think something like that could be very helpful.
And there is the flip side too, right? There's a wonderful piece, I think NPR did a series of interviews with content moderators who are incredibly overworked and burdened in the number of pieces they have to review and the amount of time they have to review them. And one of them admitted, quite frankly, that she didn't follow the standards, right? She just took down anything she thought was offensive to her, right? So yeah, some of it is that the companies aren't recognizing speech that is in fact dangerous, but also that their employees are perhaps censoring speech that is in fact quite valuable. But I want to throw an idea out here for all of you, because often when we're talking about regulating speech, we put on one hat. And the regulation of the internet has also led to a different standard of kind of responsibility and liability, right? In the intellectual property context, specifically copyright law, we actually opposed a different standard than the kind of safe harbor that exists under the CDA. And that is, we imposed a regime in the United States that follows a notice and takedown procedure. Right? So it's not on the responsibility of the internet company to determine whether or not speech is in fact infringing copyright. So if you're YouTube, you could implement filters or hire people to do that screening. Instead, we have a system where a copyright owner can complain and say that the video that was just posted is in fact infringes my copyright. YouTube is now under an obligation to take that video down, but that's not the end of it, right? In order to preserve freedom of speech and legitimate uses, YouTube now has to inform the person that posted the video that such a takedown has occurred and give an opportunity for them to come back with a response. So it essentially creates this process where the private parties can argue about the value of the speech, and YouTube kind of stays out of it. In the end, if the final person who says, this is my copyrighted work, comes in and says, I still disagree with the poster, now YouTube has to keep it down if that person certifies that they are going to bring a lawsuit to actually challenge the use, right? So can we create a regime like that instead of imposing the obligation as an affirmative one, but as a reactive one, where now we rely on the people in the country who may see that this is a threat to me, right? Or this is a threat to my group, or this is a threat to other groups, to make that initial determination and then take the company out of the decision-making process.
I mean,
Yeah.
well, I don't think that could work in a situation where you have a mass atrocity taking place. First of all, if you're operating in a country where there's very poor digital literacy, you can't expect the public to react in a way that would ensure that freedom of expression, but at the same time, the safety of the community are both preserved. So, but I do agree that companies should should listen to civil society and members of the public, but do not fully put the burden on them to flag issues to the companies. Yeah.
Oh no.
Go ahead.
Very kind of similar in terms of not sure that it is going to translate to the context where you have people at risk of death as opposed to a copyright violation. Also, in the copyright context, you're talking that the people who are flagging as notice are often well funded, highly digitally literate. So there's a number of reasons why I don't quite see the fit, but I do think this is the moment to be asking these questions because we're in this stage of experimentation. And just to add to this conversation, the proposal that Article 19 has been advancing and that David Kay has lent some support to of social media councils that bring in these different stakeholders, a multi-stakeholder kind of grouping, perhaps at a national level or more likely at a regional level, to be providing this kind of advice so that it is not just on the company, but also we don't want to just outsource this to governments. And particularly when you speak to activists across the Global South, the government is not the person that we want involved in this in particular. And I mean, it's not just the Global South, but there's appropriate wariness there.
Yeah, so I'll be a little more sympathetic to your proposal, although I share some of the skepticism that the other panelists voiced. But I think this really varies by country, right? I mean, there are some countries out there where basically anybody who's going to serve as a watchdog is putting themselves at sort of significant personal risk by playing that role, right? And that's a serious concern, and I don't think you can sort of put the burden on them, right? There are other countries where that's less true, where it might be where it might work better. Although, to the extent that we're focusing just on sort of mass atrocity, it's the places where the concern about mass atrocity is greatest, where the individuals who would play that role would be putting themselves at greater personal risk, right? If you think more broadly about the other kinds of bad speech out there, then there may, then I think there are opportunities for doing it, but you really do have to be sensitive to sort of differences between different countries and where are the places where somebody who's playing this kind of role is like putting themselves at personal risk, and I just don't think you can. I think in that context it doesn't work.
Okay, well, I'm glad, right? Because that's not what I'm proposing. Right? I'm not talking about the individual interest of any property right holder. Certainly not the idea of my life is threatened, please remove this content. But I mean, the discussion of NGOs or other organizations, whether they are on the ground in those particular countries or just essentially anywhere else in the world, they could be part of the United Nations or some other group that would actually raise these claims. So, right, in the United States, the Digital Millennium Copyright limits it to the copyright holder, right? But we could envision a system that involves notice and takedown that takes into consideration, one, the threats to individuals and groups that are particularly vulnerable, and leaves open the possibility for people who either are in those situations or represent those individuals to appreciate the cultural context, right? Otherwise, I'm concerned about the idea of having one hegemonic standard to the extent we can even create one, because especially if we're trying to find the perfect standard, that usually means we'll never come up with one. And versus kind of just defaulting it in some respects to companies to figure out as best they can in order to avoid liability.
Let me just pick up briefly on the last point about the one. So we already have one standard. It's I would dispute the term hegemonic, but we do have pretty clear international rules about a duty to prevent genocide, a duty to prevent crimes against humanity. Those terms are defined, right? So the basic norm is not really contested. How you operationalize that norm is very complicated, right? And so, if your point is you've got to operationalize it in different ways in different countries, I think that's right. I think that's absolutely right. But the norm itself is not contested. We don't need to have an argument about what is genocide, what is a crime against humanity, right? That I think we can look to international law. Oh, I was going to say one other thing about the Facebook announcement about this independent review. A couple of things that this group will appreciate in terms of what Facebook put out there in terms of guidance for its values. One is we look to international human rights standards to sort of help define what is okay and what's not okay. That's now part of their sort of company value statement in this context. And the other thing that's interesting is they specifically have something in there about human dignity, protecting human dignity, which is nice, and they're clearly not drawing that from the U.S. constitutional tradition as much as sort of looking to other constitutional traditions outside the United States that have a greater emphasis on human dignity. So I thought that was a really positive thing.
Actually, so I'm also interested in, so David mentioned a while ago about public-private partnerships, and this is outside the scope of my paper because I only talk about ensuring normative alignment, but the public-private partnership can actually be a good way to operationalize the norms, ensuring normative alignment. But I wonder how this can operate internationally. So what formal coordination, partnerships can operationalize this? So maybe I'm just thinking on top of my head that, for example, in this regard, the work of the ICC is still important. Even if the Rome Statute system cannot, in terms of liability, does not really apply to companies like Facebook, the work of the ICC, for example, when they open a preliminary examination, can guide companies like Facebook in saying, it's like the early warning project of the Holocaust Memorial Museum, to say, oh wait, at the very least, we should be paying attention to this country because there's already an FFM on it, there's already a request to conduct a preliminary examination.
So David's paper makes a very excellent argument for the liability standard. And to go to the operational question, this is where he suggests that in changing this or imposing liability, we should remove the American requirement of imminent lawless action, right? And that goes to this problem of, right, there is a standard that we all agree to about human rights and genocide, but not necessarily when we should hold people responsible in that chain. So how would you respond? Is that what we need to do to kind of really think about when we should apply an American standard, or is it just really American standards apply in America? And German standards like of Holocaust denial should exist there and not be applied in the United States. So how do we reconcile that from the global perspective and the private company's perspective?
No, it's a great question and a really hard question, and I don't pretend to have the the right answers to this. So I'll go back to, I think this is a really good time to be having the conversation. But I do, on the specific question of sort of imminence, right? I still think there was a lot of wisdom in the formulation that Judge Learned Hand came up with back in the 50s, which was before we got the sort of, imminence in Brandenburg, which was, there's a balancing here between the gravity of the harm and the, likelihood that it will occur. Imminence puts a lot of weight on the likelihood that it will occur without really taking into account the gravity of the harm. Right. So just, if I could sort of rewrite sort of First Amendment law in this area, which I can't, I would actually go back to something more like the Learned Hand approach, which is, there's got to be a sliding scale of imminence where if we're talking about a relatively low-level harm, insisting on a strict imminence requirement makes sense. But if we're talking about sort of mass atrocities, we got to be able to relax that imminence requirement to deal with the problem, because if we wait until it's imminent, it's too late.
Right, and actually Hand was a strong proponent of a much more objective standard, right? So right. If you say those words that it is time to go and do X, Y, and Z that is criminal, we should be able to punish you under those circumstances, right? As opposed to, because some people would argue that, especially with digital media would never meet the imminence standard since there's some filter to between the speech that's posted and then the people that might very well act. And we nonetheless know that social media can be very influential in ways that are quite dangerous to everyone.
Yeah, and there again, we need to understand who is the speaker. That gives us information about imminence. It's one thing if you have an ultranationalist leader putting out a Facebook post that is inciting, and it's another one if it's someone who has sort of 20 followers, and right. So context here matters.
Okay. At this point, any other comments or questions before we open it up to the audience? No.
Can I just put in one last pitch because we're so focused on the facilitating role in atrocities. I do want to just again flag before we go to questions that every solution that we try to propose here that we hope will work to reduce incitement needs to not also catch up in it the way that human rights defenders are using social media as well, and that can be a very tricky line to straddle at scale.
Go ahead. You have the microphone. You can make this call.
So closer to the mic gets me the first question. I'm not sure, as an amateur outsider picking up some CLE, I understood the full import of what was said, so I could get it wrong. But as I understand it, you want to impose what would be called under American tort system secondary liability. That is, the wrongdoer isn't being sued, but the vicarious or secondary or tertiary player or agent is. And you want to potentially impose as a negligence standard, since we're not really thinking anybody in Silicon Valley is at their, drinking white wine at the Fern Bar is actually interested in killing people in Asia. That under the extremely vague negligence standard that has characterized American law since at least Buick versus McPherson should apply. And the negligence law implies no standard. It's not a standard that everybody here is talking about. There is no standard. There's nobody who actually pays attention to negligence law that thinks there's a standard. It's whatever that jury does that day. And the potential here is death penalty sanctions. Now I hear a vague Marxian whiff up here. Well, since they're all rich at Facebook and at Google, who cares? But let's suppose we're not Marxists. Suppose we're American constitutionalists or capitalists in a mild sense, without being Milton Friedman, my old professor, who. So I'll make that as an admission. But let's just suppose we want to be fair to everybody in some way, regardless of whether they can afford a $10 billion verdict or not. And we're not going to care that it's Texaco versus Pennzoil or it's your neighbor's tree coming down on you. What you're really saying is that by putting this sanction in, you could put these companies out of business. You're putting them potentially out of business as a secondary or tertiary wrongdoer. You're doing it with no standard, and you're violating anybody's idea of free speech. Not an American idea, but if you read the sort of abstract literature on, let's say, political philosophy about free speech, that somebody who sits there and is a bookstore or a library or a radio station with an open mic is liable for death penalty sanctions. I'm sort of it's hard to sit there and be tainted with this, that I'm on the side of the genocide here, but I don't understand why this particular American tort standard, and the American tort standard is unique. Nobody's giving billion-dollar verdicts around the world, just America. So maybe we're unique on free speech. I don't think we are, but maybe we are. But we're certainly unique on tort law, which is something I don't know much about. A lot of this stuff, as you could probably tell, but I know a lot about tort law. And we're unique on tort law. And why we would suddenly ask some jury in Cody, Wyoming, to sit there and, because that's where something is venued, to decide whether 1,000 or 10,000 innocent people were slaughtered because Facebook didn't take down a post within 24 hours or 48 hours or whatever is reasonable. And reasonable is the only standard, which is no standard. And if they decide, yeah, it was terrible and we're going to give $20 million per person, which may not be enough, and Facebook will be bankrupt, but of course you may not care because you're mildly Marxist. But why is that a good solution rather than international standards for states who signed the treaty, states who have armies, states who have to answer to their majorities? I mean, why is it suddenly in the interest of some people who are lucky enough to bought stock in some company that is obscenely rich? Why is it their responsibility? I don't get that at all.
Okay. So I just think your premise that there's no standard is wrong. There is a standard, and, if you think about the way medical malpractice works, right, you can't get a judgment in a medical malpractice case without actually getting a doctor to come up and testify that this guy didn't follow professional guidelines, right? And so what I'm talking about here... Find a doctor to say that. Okay. Okay. But
thank you, sir. If you could let the panel respond.
But, this is why I sort of put into my proposal that you have a, sort of a group composed of government and industry that basically identifies, here are what are practices that are reasonable to expect. And if you conform with those practices, you basically have a safe harbor and you're not going to be found liable, right? And you don't have, like, as you do, and I mean, I suppose if, you could develop here a group of plaintiff side experts, like, if this actually took off, right, who would come out and do the role of the plaintiff side experts in medical malpractice. But I think it's a very different kind of environment. So I actually think if this proposal was adopted, you wouldn't get huge, multi-billion-dollar judgments, because you would basically get the industry to come together, define a set of what is best practices, and as long as they conform to that, they sort of avoid liability. And just one other thing about that right now, there's big differences between what Facebook is doing, what Twitter is doing, what Google is doing. Then you got some smaller companies out there too. So, getting some sort of uniformity here, I think, would be a benefit.
I just want to be clear that it seems to me that the discussion started, in a sense, over the events in Myanmar. And I'm just wondering if you were to hold Facebook or anybody else accountable, what would the crime be? Or what would the case be? Because in a sense, they were carrying hate speech, but hate speech was out there. The actual crime was carried out, it seems to me, by the state. The state planned it, the state organized it, the state had all sorts of ways also of covering their tracks, and that the hate speech was a supportive factor, but it doesn't seem to me that it was the actual incitement. And I'm just wondering whether the panel, because I don't know whether this has been adjudicated anywhere, but just what happened there in your minds that deserves some kind of criminal or civil or other judicial action?
So certainly there's a case for criminal liability against the actual perpetrators. And we're seeing part of that case potentially moving forward at the ICC, although it's very complicated jurisdictionally because the ICC only has jurisdiction over Bangladesh. So it's what crimes, an element of which were not complete until the Rohingya got to Bangladesh itself. So we'll see where that goes. And then there are people doing documentation now for a hoped for future criminal case in who knows what venue at this point for those international crimes that have been committed, genocide and crimes against humanity. That is a separate but related conversation from what liability there might be for a platform where there is absolutely, I don't think there's any question where none of the officers involved in Facebook, no one sitting there in California had anything near, it's crazy to have the mens rea conversation about that, right? It's not a criminal mens rea conversation. And that is why I think we're talking about things that move outside the realm of criminal law. Because I don't think that trying to shoehorn this fact pattern of the platform into criminal law is necessarily the best way to go, although there are certainly people making the aiding and abetting case.
Sorry, if I may just add, under international law, there will be no crime and no case because the UN Guiding Principles just offers a soft law framework. And so whatever Facebook does has no legal repercussion.
No, there is incitement, but that's not by the platform. That's by the
natural person, the speaker. the one who posts on the platform, but the platform itself, there's no legal
But
repercussion.
the platform is essentially facilitating that incitement through its inaction, right? And that, like I said, that fits into at least roughly a sort of a civil liability model, but doesn't really fit into a criminal model.
So,
Criminally, yes. Right.
Yeah, no question.
can I pose a slightly different question? Because I agree with Rebecca that this is a time that new frameworks can be, like we've seen something awful happen. It was actually the Myanmar generals who were on the platform, right? But if there was another Myanmar type situation, I would have very little sympathy for Facebook at that point, because we've seen how their platform has been misused. And I think there, you could actually get into criminal aiding and abetting in a subsequent situation if they weren't quick enough to at least stop incitement by state actors. And so I'm wondering, I think Myanmar, I hope we don't have lots more of these situations, but I think, they've been warned, right? This has actually happened. The platform has actually been used. And so I think in future cases, it would not be unreasonable to say that I wouldn't give up so quickly, is what I'm saying, on the criminal law. There have been some very interesting prosecutions in European courts of individuals who sold gas to Saddam Hussein, of individuals that participated through, or corporations, in the commission of a genocide or crimes against humanity elsewhere. And so I think Facebook is, to the extent that it acts recklessly, having a committee of oversight is really not sufficient. This is a company that earned, and I'm sorry to sound Marxist, but their net profits were $22 billion last year. They have the ability to cope with the fact that they have a global platform that could, under certain circumstances, be, aiding and abetting the commission of atrocity crimes. And so I think taking this really seriously means not sort of being glib about it and saying, okay, maybe in Myanmar you didn't actually know, and there is not a way to attach potential criminal liability. In a future case, I would be much less hesitant to say you may be criminally responsible if your platform is actually being used. And I just want to throw that out there, because this is a hugely, they're sort of providing a quasi-government service in a strange way, right? I was trying to figure it out. I think they have 20 million users in Myanmar. They have almost 3 billion users worldwide. So getting some kind of a handle on this, I think, is really important, even if it's not retrospectively with respect to the Myanmar case. In future cases, I think you really could be looking at liability, and I certainly wouldn't hesitate to do so. So I'm just interested what your thinking is about that.
Actually, I'm not so sure that it could fall within the framework of aiding and abetting, because the knowledge requirement there is knowledge of that specific act. And are you referring to like domestic? Okay, I see. Okay.
Yeah, I mean, to respond to your point there is also the danger. I mean, because the topic is about genocide and the atrocities that happened in Myanmar, there is this concern, or kind of essentially our thumbs on the scale of thinking this is a horrific thing, right? And it is. But the flip side is Facebook or some other social media company or some cellular mobile phone provider, if they're faced with the risk of, we may be considered aiding and abetting, even though we have no purpose to do so. We won't expand our facilities and our services to countries where, keep in mind, right? I mean, it was the fax machine that helped organizers of pro-democracy in Tiananmen. It was text messages and Instagram that helped protesters in the Middle East in the Arab Spring. So we can't control how this technology is used, and we know there is horrible things being done with it, and there are trolls and dark spots on the internet all over. But this communications technology, going all the way back to the printing press, can be used for good and bad, right? So I'm concerned, and I know the panelists are, to find a balance between that, and I just think we here and some of the audience too disagree on how we draw the line for that balance.
Maybe just in closing, a comment that stuck for me in an interview with an activist in Myanmar is, we want Facebook in Myanmar. We just want a better Facebook. And I think that's what we're all trying to get to here. How do you structure those incentives to get them to do a better job?
Right, if you could join me in thanking our panelists. Thank you.
Thank you, Raymond, for chairing an incredible panel, and thank you all. All right, so we have 15 minutes for you to freshen up and get your lunches. They are in the rotunda, which is the room behind this. The lunches include chips and drinks and 4 different kinds of sandwiches. You can bring them here, and the next panel is an eat-in panel. It's like a drive-in movie. And you're going to love this panel. It's got a lot of different people on it, and the topic is dealing with the Yemen crisis.